The state of the matters regarding Dr. Kizza Besigye and Obeid Lutaale, the status of their case. I'm sure many of you are wondering as to what is going on. We want to update you on the progress, if at all there is any, and the actions we are taking. You recall the last time we appeared before court, they had tried to pursue an application to open Dr. Besigye and Obeid Lutaale's phones so that they could access the data on those gadgets. And after a spirited fight that we put up, finally, Her Worship Nantege had to dismiss the application because obviously she had no jurisdiction after committing Dr. Kizza Besigye. As we speak today, Dr. Besigye and Obeid Lutaale have clocked 240 days on remand in Iruzi. 240 days. The Constitution is quite clear and very, very instructive in Article 23. Once you have clocked 280 days, rather 180 days, you're entitled to mandatory bail. We don't need to repeat this time and again. Once one has been on remand for a period of 180 days, they're entitled to mandatory bail. But there have been machinations and maneuvers within the justice system that have thwarted all these processes of getting bail. First of all, we take exception to those maneuvers, those machinations, the manipulations that have been going on in the criminal justice system to deny Dr. Kizza Besigye bail and Obeid Lutaale. It's very, very unfortunate and regrettable. Secondly, we filed applications for bail. My brother, the Honorable Semuju, has alluded to one which was before Comfort Kenya, which was dismissed without any justifiable reason, after the judge being convinced that actually Dr. Besigye and Obeid Lutaale had satisfied all the conditions and requirements for grant of bail. But that notwithstanding, she denied them their right, which is guaranteed under the Constitution. But now what is happening? We subsequently filed 2 applications. The head of the criminal division of the High Court, Justice Baguma, allocated these files to Justice Emmanuel. That's not true. The head of the criminal division of the High Court is called David Matovu. Sorry. It's called David Matovu. Allocated the 2 files to Justice Emmanuel Baguma. Now, since May, when these applications were filed, we are now in July. The interruption because I'm being distracted by this. So I was telling you, Justice David Baguma, who heads the division, the criminal division of the High Court, allocated these 2 files to Justice Emmanuel Baguma, David Matov. Now, Justice Baguma, up to now, has refused to fix the bail application. Time and again, we have faced him. We have had the conversation and discussion with him on these matters and put it squarely to him that please, you have a duty to fix these matters, have them heard, and you decide them one way or the other. Can you imagine the arrogance he has exhibited? He told us in our face, in no uncertain terms, that he's not going to fix those applications. He has totally refused. He said do whatever you want. I am not fixing these applications. Then we asked him, please, can you return the files to the person who assigned them to you, the head of the division, Justice Matov? Again, he refused. He's holding onto the files, but he's not ready to fix them for hearing. We had to write a complaint to the head of the division and copied in the principal judge. Up to now, we have not been favored with a response from the principal judge or even the head of the division. They have all kept quiet. We have all these communications. There is a trail of communications which we'll share with you. Then you wonder what they are up to. That is the status of the bail applications. Now, regarding the main case, you recall on the 29th of May, Dr. Besigye and Obeid Lutaale were committed to High Court for trial. And what happens, once you are committed, the file from the Chief Magistrate in Nakawa was supposed to be transmitted to ICD, because that's where the trial is going to be conducted from, to the International Crimes Division of the High Court. Up to now, Her Worship Nantege is still holding on to the file. It is still in Nakawa. Up to now, it has not been forwarded to High Court, the ICD. You ask Nantege, you did your work. You are supposed to handle pre-trial processes. You are supposed to process the issues to do with the investigations within 6 months. That was done. You tried to extend your time. We frustrated it. We thwarted it. We blocked it. Legally, we blocked it. Now, what is it that you are doing with the file of Dr. Besigye and Obeid Lutaale after committing them to High Court for trial? She cannot answer that question. So these are the frustrations we are expressing to you, which we have registered. We wanted the matter to be fixed for hearing at ICD. We faced the registrar at the ICD. That can't you fix it in a session to have the matter heard? Said, but the file is not here with me. Then we asked the registrar of the ICD, can you write to the magistrate to bring it? He said, but we are not notified that they have finished the trial, the pre-trial processes. They have no record whatsoever that Dr. Besigye and Obeid Lutaale have since been committed to High Court for trial. That's where we are now. Now, what do we intend to do? We have agreed. We are going to assemble here in a week's time. All of us at Katonga here, we are going to let you know that we are going to face off with the principal judge. Yes, we are going to assemble here. We are giving them only 1 week, within which to process all these issues and to this kind of ping-pong to come to an end. We want this ping-pong to come to an end within 1 week, or else we storm the office of the chambers of the the principal judge, and cause these matters to be fixed for hearing. The Constitution commands that one is entitled to speedy and fair trial. You can't hold the people incommunicado without trial. Totally unacceptable. So we are saying, please, if they are not ready to process this matter, to have them fixed for hearing, then let them release Dr. Kizza Besigye unconditionally. So we are going to face off with the principal judge over this matter. If we don't get a remedy, then we shall square up with the Chief Justice, and we are not going to leave any stone unturned until we have gotten justice for our people, Dr. Besigye and Obeid Lutaale, and all other political prisoners. That is the position. Related to that, I want also to bring you at least some positive news that our colleagues in Nairobi, you know, the legal team is headed by Senior Counsel Martha Karua. So even Nairobi, we assembled up a legal team, a very, very strong, formidable legal team, which is pursuing these matters that side. And in the course of today, the team in Nairobi is filing a case against the government of Kenya for the abduction of Dr. Kizza Besigye from within their territory. This is not IARA. This is High Court Kenya. Rather, yes, High Court of Kenya in Nairobi. They have their Constitution and Human Rights Division. That's where the matter is being filed today by our legal team in Nairobi. Today. We have finalized the necessary paperwork. They came here, brought the affidavits. They were signed by Dr. Besigye and Obeid Lutaale from Luzira. The law requires that if it's cross-border, whatever litigation, you get all the papers this side notarized. We got a notary public who went to Luzira, notarized these documents, and then we sent them back to Nairobi. Now the team has finalized the necessary paperwork, and the filing is today. And these are the offices that have been dragged to court. The Cabinet Secretary, Ministry of Foreign Affairs, the first respondent. The second one is the Cabinet Secretary, Ministry of Defense. The third one, Cabinet Secretary, Ministry of Interior and the National Administration. The fourth one is the Inspector General of Police of Kenya. The Director General of the Directorate of Immigration Services, and the Honorable Attorney General as the sixth respondent, and then the seventh one, the officer in charge, Malaba Border Post. The reason, one, abduction and kidnap of Dr. Kizza Besigye, not taking them through the due process there before deporting them, because they needed to be declared them as fugitives, criminal fugitives in Kenya, and they had to seek for court orders within the judicial system of Kenya for an order of transfer back to Uganda. That is what is provided for in the Extradition Act of Kenya and Extradition Act of Uganda. They never followed the process, the due process provided for in the Extradition Act. Two, they also violated the territorial integrity of Kenya. The Attorney General and all these people allowing mercenaries from Uganda to cross the border, kidnap individuals who are protected by the laws of Kenya, and bring them here without the due process. And finally, violation of the immigration protocols. Because the immigration protocols require your papers are supposed to be, processed at the border point. They have to be stamped on either side of the border. This never happened. So, and a number of other grounds. So, this is, at least, this gives us a glimmer of hope, because with Kenya, their justice system is a little faster compared to ours. You recall even during the recent Mandamano, when they had slammed the blackout on the media, live coverage, immediately they went to court. Within an hour, the order had been issued out. So we are sure this one is going to be expeditiously handled in Kenya, and it's going to give us one of the remedies we expect to get.